Judge, we just received those letters.
And
Yeah,
thank you.
I
Leslie.
haven't looked at them.
And I think they were attached to the PSI too. I apologize.
One of these is from the defendant, is that right? Did you write that? She gets to read it.
I have a copy, Judge.
You have a copy of
Yes.
this already? Anytime anything sent to me goes also to the state. There's not a confidentiality here unless the law provides otherwise, which it seldom does. Is Michael Lind here? I know he wrote a letter on your behalf. I've never seen this salutation. Did you read this? That was a very unique. I've never seen that written ever in my whole life. Of course, he's a church pastor, and sometimes they use words in an expression to
Right.
ensure that the thought is conveyed. Like, and that is the first time I've ever seen that used that way. What church is this? Y'all go to this church?
Yes, sir. It's
What church is it?
Golden Triangle Church on the Rock.
Oh, Church on the Rock. Oh, yeah, that's a well-known church. Well, here's another. This is from the youth pastor from that church
Yes, sir.
too. And this is from a teacher of yours from Nederland.
No, sir. She goes to the same church.
It says
I've known her along the way.
NederlandISD.org.
Yes, sir. We go to the same church, and I've known her my entire life. But I never went to Needle ISD.
It says her name at NederlandISD.org. Was she a teacher?
Yes, sir.
Oh, okay, that's where it is.
Sorry.
When was she a teacher? Do you remember?
I believe she still teaches. She's been teaching for over 20 years, I think.
Because I was on the Nederland school board when I was in private practice at Provost Humphrey a long time ago. Before federal U.S. attorney work in this job. That was 40 years ago. Believe. Yeah, you sent me a letter for her.
Oh, so
I'm going to play like I didn't read that.
Cause I'm following along as you're
Yeah.
marking, and I'm like, I don't have that one.
The next one.
Okay, I've got three.
This week.
Stand by. Three letters and then one written from the defendant.
Yes, sir.
A fourth. Anything else
No, sir.
on letters? Okay, the fourth. Okay, the court has read those. All right, so we call cause number 25 CR 703, the state of Texas versus Preston Simon. And the defendant is present with his attorney, Mr. Lane, and the state's attorney. Earlier, the defendant entered a plea of guilty in December, on December 15th of about a month ago, pleading guilty to the indictment here of credit or debit card abuse, a state jail felony. A pre-sentence report has been prepared. If the parties had an opportunity to review it, are there any questions, changes, or objections to it? State
Nothing from the state judge.
and defense.
No, sir.
It's made a part of the record for all purposes. The agreement is not an agreement at all, other than he agreed to plead guilty and throw himself, I guess, on the mercy of the court, as it were, and rely on obviously other parts of his life that were well intended and accomplished rather than this event.
Yes, sir.
So it's an open plea. There isn't an agreement by the parties, so each side gets to add any additional information and request the court to consider a particular sentence, and then the court will make its decision. My question for the state, and I'm going to ask the state to, she can go first and last.
Sure. Sir.
The I sense from reading this that the victim in this case, what does she wish? Because victims are heard.
I have her here, Judge, and I would like to call her and ask her a few questions,
Oh.
if that's okay with the court.
That's fine. You may.
Yes, sir. The state calls Miss Stacy Aber.
Come forward, please. And we're gonna, on this one, I'm gonna mute this, so she's not on YouTube. I'm not gonna do the victims or when they testify at sentencing hearings. Our practice is to mute this. So what we want to do is, we've heard the victim's point of view. I have read this thoroughly, like I do. I prepare. I've always been that way. And that jumped out at me. This is not usual. What your statements were not consistent with what you pleaded guilty to, nor what the indictment alleges. But I'm looking at all this other material about you and what people write about you, and it's fabulous. I mean, you're well thought of. People believe that you're a wonderful person, and I'm not saying you're not. Something is wrong here. I think she's probably a wonderful person. She's a victim here. I've done this long enough, and when I read this facts, and then the way you explain it, it doesn't work. And whether it's just intimidation of this around surrounding or what, y'all have entered into an open plea where I could sentence you to 2 years in the state jail, and that's 2 years. You don't get parole. You go 2 years, which is one day is a lifetime. I've been around this for 40 years, and as a district attorney, a defense attorney, a United States attorney, and now a judge. And I wouldn't want to be incarcerated. It's terrible. Loss of freedom is a precious thing to lose. But honesty and forthrightness. If you're going to plead guilty and make statements under oath, you got to conform to that. But a lot of people, young people sometimes get intimidated and they're hedge a little because they're afraid of what the consequences may be. Absolute forthright truth is what's important. That cleanses everything. But sometimes the truth can send somebody to prison, or even worse. But this is no different. We're handling this no differently than we do in all other cases. Something doesn't seem right. You have an opportunity to change this if you wish. And maybe you misunderstood, you were intimidated, you froze. This is something that you've never dealt with. You've never dealt with before. I don't think your decisions, you've never had to make a decision whether going to prison or not was at issue. And I read it and it doesn't make sense. And credit cards are different. They look different. And her statement, her story, she doesn't have any, that lady is a victim. She doesn't have anything to lose or gain by not telling the truth. So she's just it seems forthright, and it was what she said before. And I've got between your statement to the pre-sentence officer and your statement to the police don't match a plea of guilty to the terms and elements of the crime. Or can you explain it and resolve that or not? Well,
Your Honor,
give it your best shot. Remember, you're under oath.
Tell the story.
And you have pleaded guilty to, remember, you pleaded guilty under oath here to knowingly and intentionally using a MasterCard, knowing at the time it was without the effective consent of the cardholder and without her consent, and knowing that it had not been issued to you. Those are the elements of this offense.
Yes.
But what you've told the pre-sentence report officer and what you told the police was I don't know how it in a miracle fashion or something ended up in my apron. I used it and I didn't notice it was different from my card, which, if true, if that miraculous event occurred unexplainably, it would not be a crime that you pleaded guilty to. But the court knows better. I've done this so long. I know. And you're young and you've never been in something like this, but truth is important. It only compounds a problem. And perjury is another crime. So, Brian, help us out. How can he explain it? Or not?
It has been.
I can't do it.
I think the court, his father, from moment one, all the interviews, I was there. I took him, we took everybody, we immediately tried to accept responsibility.
Shed some light. And
I think, well,
conform with
two things.
Conform with the elements of the crime, or else.
Two things that happened. The actual receipt and use of the credit card and actually using the credit card and trashing the credit card was the abuse. That was the wrong occurrence, that he took the card and he threw it away. He's always admitted that he used it twice. Respectfully, to Miss Abear, that was his brother that was at the restaurant that day, because after you came by, they let him go and he's never been allowed to go back.
It was him.
It was, his brother looks just like him.
No, it was him.
Okay. It wasn't him. He's never been allowed back at the restaurant after that day, after she came.
She's the one that testified under oath, not you.
You're allowed.
Yeah, but you weren't a witness to that. She was.
Place it on the child out here.
All right. All right. Here's what we're going to do. Yes, ma'am.
Say something.
Yes, ma'am.
He was there. He was
I
sitting
understand.
home after I went back the second.
Yes, ma'am. All right. If nothing changes, if this is where we're going to end, this is what's going to happen. This court is going to withdraw this plea of guilty because it's not supported by the record. It would be convoluted. And we're going to we're going to be truthful on this, then it will be set for trial
Yes, sir.
and a jury trial. And a jury may or may not allow probation.
Thank you.
But also, here's another thing is that at trial, all of these proceedings that you've testified to and about are going to be part of the record and will be admitted. And you need to start figuring out how you're going to claim under oath you pleaded guilty to intentionally and knowingly, but told everybody else that it was only an accident. Those are some issues that are going to be a little tough to deal with. But it's your line. And we'll put it on the trial docket, and that's what we're going to do. All right. This is going to end up in a catastrophe, but you know it. This is where it's going to end up. But I've done this long enough, and
Control.
nope, you can't. You can't. He's got to live by his own statements, and he's got to either be forthright or not. All right.
He wants to move forward with his pleas. That's what he's saying. That he wants to override counsel's desire to put it on the trial docket. He wants to move forward with his plea.
Sir?
Yeah, I just wanted to say one thing. The truth never changed. It was always the truth. I did mistakenly use it, but the reason I pled guilty was because no matter what, I still use a card, and I wanted to take full responsibility of that, and I wanted to apologize to the lady.
But sir, that's not the way it works. You've got to plead guilty to the elements of the crime, and the elements that we went over this. The elements of the crime, which you stated you did, was you intentionally and knowingly used her MasterCard, knowing it was without the effective consent. Not, oh, I didn't realize it and it was a mistake. A mistake is not a crime. You either knew that it wasn't yours and she had not given you the consent or not when you used it. That's the issue. Did you or did you not? Did you what?
I did use the card, sir.
And did you know it was at the time it was not yours, it was somebody else's, and she did not give you the effective consent to do it? Is that what you're stating?
Yes.
Sir?
I knew I did it, and
Was that without her consent?
was it?
Was it without her consent? You knew it was
Yes, sir,
without.
without her consent. And I just wanted to make her.
Apologize to her. I think she's the kind of lady that would accept it if you're forthright. I don't think she wants to see anything bad. She just wants the truth.
Yes, sir.
Tell us what the truth is.
I just want to apologize.
I'm so sorry.
I'm really sorry. I never meant to cause any harm or anything. And when I did find out, I really did want to apologize to you and reimburse you for that. In the moment, I didn't mean to use it. But after I found out it was not mine, I just panicked. I've never done this before. So it's so.
All right. So, once again, let's make sure you're still under oath. Did you commit the state jail felony of credit or debit card abuse by intentionally and knowingly using the victim's MasterCard, knowing that the use was without the effective consent of her, namely without any consent of any kind, and knowing that that MasterCard had not been issued to you? Is all of that true and correct? So help you God.
Yes, sir.
Okay. Well, the court has considered all of these letters, and is there anything else you want?
Just closing.
Yeah, you may. Go ahead.
Yes, sir. Judge, even after you pointed out what's in the PSI as well as the defendant's letters, all the way up to the apology that he just gave, he still does not accept full accountability. He is still grasping onto this like in your words, this miracle fashion that her card appeared in his apron. He had no interactions with her at that restaurant that night. He still won't take accountability for the fact that he picked the card up from somewhere, whether it have been she dropped it on the table, she dropped it on the floor. He picked the card up and he still will not take responsibility for that. He still wants the court to believe that her card appeared in his apron. Secondly, he wants the court to believe that he went to two businesses and closed his eyes or turned his head and either tapped or inserted a card without knowing that it wasn't his card.
Yeah,
If you go to Chick-fil-A,
that didn't make any sense.
if you go to Chick-fil-A, there's either a tap or a machine. You don't pull the card out and you stand there and blindly tap and you have no idea that that's not your card. You don't go to the gas station and walk up to the machine and turn your head. He still won't take that responsibility.
Okay, not to interrupt you, but I think he is. He just hadn't gotten to that point, but he has admitted that when he used the card, he knew it wasn't her card. He's admitted that. That's it. Isn't that right? He knew what. Now, how it fell into his apron is a mystery that we haven't gotten to, but that's not an element of the offense. How it got in his possession isn't an element of the offense. It is in his hands, in his possession, and he misuses it because he knew it wasn't his to use and he didn't have the permission to use it. You're admitting to that. And how it fell into his apron isn't, I'm curious about it, but it's not a necessary element. But he has admitted to the element of misusing, and it's what he did in those other two events that you're talking about. He did this. It was essentially the misuse of it because you knew it wasn't yours to use. This is completely separate and apart from what everybody says about you and what we know about you there's nothing, you're clean. Your history is clean.
Yeah.
You fouled up. And I wish I could say I never did. We all have. But it's how you fix the mistakes. That's the test of character. Even if it takes a little while, you got to face it, which is what you're doing. You apologize to the lady. She's a victim. She has a right to be heard, and she has a right to be for the truth to come out, and she has a right to forgive if she wishes. But I'm accepting the plea of guilty under these terms, completing the record that coincides with the elements of the offense. Find that there is sufficient evidence supporting your guilty plea from the statement you have made today under oath and before. Did you want to add anything? To find you guilty beyond a reasonable doubt. Now, the next step is what direction we take. What's state asking for?
The state is asking for the court to put him on probation, Judge, whatever length of time the court feels sufficient.
Is that all right with you, ma'am? All right. There is enough to find you guilty. I am going to defer or postpone any finding of guilt so long as you follow the terms and conditions of the deferred or unadjudicated probation order. You've gotten a second chance. Make the most of it. Live honestly. Harm no one. Give each person respect. Those are the three elements of life. And I'm sure your pastor who wrote a letter on your behalf, what he says equals is tantamount to what we're doing here. And that is trying to save souls and render justice for all concerned, victims and defendants. You can't let the embarrassment of it all, which is what I think it's all about. It's embarrassing because it's contrary to your character. You just trying to find an honorable way out of this. But but it's not the right way to hedge, because the way the law is built, it catches that by people try to say, I'm guilty, but this is the way it is, and it doesn't conform to the elements which I have to police. And the law was written in a way that you can't, it's not like horseshoes where it's close. You have to hit a ringer to be credited with, you got to follow the law. And I'm placing you on probation for 5 years. You are always rewarded. All probationers are rewarded. Your probation term can get cut to 1/3 if you do well. You can, that's less than 2 years. There will be terms and conditions of probation. One of the conditions will be completing a theft prevention class, and that's again, not to call you a thief here, but it's a good thing for everybody to. I think everybody should take it, because what it does is it makes you think of what your choice, a wrong choice, is going to result in with future situations that arise from that wrong choice, like what you try to do and trying to substantiate by not acts that didn't conform with what you pleaded guilty to. But you're an honest person. You failed. Fix it. Move on with your life. We all make mistakes. Don't do it again. All right. I've signed this order. Here they are. Please see the probation office, and good luck.
Thanks, sir.
Yes, sir.
Is the restitution not listed?
How much did you lose in this, ma'am? Was there a loss?